Welcome back to the deep dive.
Every time I start looking into a topic like U.S. immigration,
Hmm.
I realize just how much I thought I knew, and then, well, how wonderfully tangled the reality actually is.
It really is.
So today we're going to try and cut through some of that noise, really get to the bottom of who's who in the eyes of U.S. law.
Yeah.
Our mission for this deep dive: simplify, clarify, and help you truly understand the different labels, I guess, people have in the U.S., whether they're U.S. citizens, immigrants, non-immigrants, and, oh yeah, that notoriously tricky resident alien term.
That one always causes confusion.
Exactly. Because, trust me, it's far more nuanced than just citizen or foreigner, and understanding these distinctions is, well, it's absolutely vital. Whether you're maybe navigating the system yourself, or you know someone who is, or maybe you just want to be truly well-informed about a complex and incredibly impactful subject.
It's true, the layers are fascinating, and it's easy to get lost in the jargon. What's truly intriguing here is how each classification isn't just a label, it's a legal identity.
Right.
With a unique set of rights, limitations, potential pathways. So our goal today is to give you a crystal clear, structured breakdown based on our analysis of these key classifications, helping you grasp not just the definitions, but also the real-world implications that honestly shape millions of lives.
I'm ready to peel back those layers.
Yeah.
So let's begin at the very top. The foundational status, U.S. citizens.
Okay.
When we talk about a U.S. citizen, what are we really describing?
Well, fundamentally, it's an individual with full legal membership in the United States.
Full membership. Okay. And how does that happen?
It can happen in a few key ways. Most commonly, it's birthright, meaning they were born right here in the U.S.
Even if their parents aren't citizens?
Yes, exactly. Then there are cases where someone is born abroad, but to U.S. citizen parents under certain conditions, of course. And finally, there's naturalization. That's the process where foreign nationals, after meeting specific residency and other pre-rigorous criteria, pledge allegiance and become citizens. Okay, so birthright, birth abroad to citizens, or naturalization. But what does full legal membership really mean in practical terms? Like, what rights come with that?
It means they hold the ultimate key, really.
Yeah.
U.S. citizens possess the most extensive set of rights and protections.
Such as?
Well, they can vote in all elections, federal, state, local. They can apply for basically any federal job. They can get a U.S. passport, which allows largely unrestricted international travel. And crucially, they have the strongest ability to petition for relatives to immigrate to the U.S. That's a big one.
And you mentioned security. How secure is citizenship?
Unlike other statuses we'll discuss, citizenship is virtually impossible to lose involuntarily.
Yeah.
Except in extremely rare cases like, formally renouncing it, or maybe conviction for very specific serious crimes like treason.
Wow, okay.
It truly is the highest tier of connection to the U.S.
That distinction about how hard it is to lose citizenship, that's powerful. So if citizens are the bedrock, what about those who've made the U.S. their permanent home, but they aren't citizens yet? How do they fit in?
Right, so that brings us to immigrants, or more specifically, lawful permanent residents, LPRs.
Ah, green card holders.
Exactly, that's the common term. These are the individuals widely known as green card holders. Imagine someone, let's call him Alex. Maybe he came here first on a student visa. A green card holder is a foreign national who has been granted the legal right to reside permanently in the U.S.
Permanently? That sounds pretty solid.
It is. It's a massive leap beyond any temporary presence. They can live and work permanently anywhere in the U.S. And they also have a clear pathway to citizenship. Typically, they're eligible to apply after 3 or 5 years, depending on how they got the green card.
Like through marriage or employment.
Exactly. And they can also sponsor certain family members for immigration themselves, though maybe not as broadly as citizens can.
Okay, so it's permanent residence, sounds like a lot of rights, but I sense there are still nuances. What are the key limitations? What makes it different from being a full citizen?
That's a critical point, yeah. Many people miss this. While permanent is in the name, it's not absolutely unassailable like citizenship.
How so?
Well, for one, green card holders cannot vote in federal elections. That's a big one.
Right.
And their status, while permanent, can be lost. For instance, certain criminal convictions can lead to deportation, losing the green card.
Okay.
And this is a big one people might not realize. Extended absences from the U.S.
Like going on a long trip.
Yeah, particularly more than 6 months at a time. That can trigger scrutiny from immigration authorities when they try to come back. The question becomes, Do you really intend to reside here permanently if you're spending, say, 8 months a year abroad?
Ah, I see.
We've seen cases where individuals, after long vacations or work assignments elsewhere, found themselves in proceedings to determine if they've actually abandoned their green card.
Wow. So it's a permanent residence status that requires you to actually intend to reside here permanently and prove it through your actions.
Precisely. You have to maintain those ties.
That idea of permanence not being ultimate security, that's a crucial point. A real myth buster, maybe.
Definitely.
Okay, now shifting gears a bit. From those building a permanent life here, what about the, well, millions of people who are in the U.S. for a specific temporary purpose? Students, workers, visitors. How do they fit into this system?
Right. That leads us neatly into non-immigrants. These are foreign nationals admitted to the U.S. for a temporary period and, critically, for a specific purpose. And here's the key idea. They enter without the intent to stay permanent.
Okay, so temporary and specific purpose.
Yes. And the fundamental principle for almost all non-immigrant visas is the requirement to demonstrate what's called non-immigrant intent.
Non-immigrant intent, meaning?
Meaning you have to prove to the satisfaction of immigration authorities, often when you apply for the visa or enter the U.S., that you plan to leave the U.S. when your authorized stay or visa expires.
So it's like borrowing something from a friend, you use it for the agreed time, then you give it back.
That's a good analogy, yeah. Think of it that way. And we see this with a huge range of people.
Like who? Give us some common examples.
Sure. F1 visa holders, those are international students, like our hypothetical Alex might have been initially.
Okay.
H-1B visa holders, those are specialty workers, maybe skilled professionals in tech or medicine.
Right.
B1, B2 visas, those are for visitors, whether for business or tourism. Think of your cousin visiting for the summer.
Gotcha.
J1 visas cover exchange visitors, a really broad category, from au pairs to research scholars. And L1 visas are for intercompany transferees, maybe a manager from a multinational company coming to the U.S. office.
So lots of different reasons, but the common thread is temporary stay and a plan to leave.
Exactly. Each category serves a distinct temporary purpose, and the underlying assumption for most is you're here, you'll do your thing, and then you'll return home.
That makes sense. Okay, let's zoom in on a couple of those because I know they generate a lot of questions. The F1 for students and the H-1B for specialty workers. There's some really interesting distinctions there, aren't there?
Absolutely. And they're often where the first real complexities start to bubble up.
Okay, let's start with F1 students.
Right, F1 visa holders. These are international students pursuing full-time academic programs, colleges, universities, sometimes even high schools. Their core intent, as we just discussed, is paramount. They must prove that non-immigrant intends to plan to return home after their studies.
And what about work? Can they work?
Their work options are quite limited. Generally, it's restricted to on-campus jobs, maybe 20 hours a week during the semester, or specific practical training opportunities.
Practical training, like internships.
Sort of. Think optional practical training, OPT, or curricular practical training, CPT. But critically, this training must be directly related to their field of study.
So no working just anywhere to make extra cash.
Generally, no. And importantly, there isn't a direct path to permanent residency from an F1 visa alone. It's not designed for that.
But people do stay sometimes, right? How does that work?
Yes, they can transition. For example, an F1 student might finish their degree, maybe do OPT, and then get sponsored by an employer for an H-1B visa. That visa might then offer a path to a green card, but the F1 itself doesn't lead there directly.
Okay, so it's a stepping stone, potentially. Now, you hinted earlier about F1s and taxes. How does their immigration status connect, or not connect, to their tax status?
Precisely. This is where the plot thickens, as they say. For tax purposes, F1 students are often considered non-resident aliens.
Non-resident aliens, even if they live here full-time.
Yes, typically during their first 5 calendar years in the U.S. Even if they're living here year-round, going to classes, fully part of campus life.
Huh. So what does being a non-resident alien mean for taxes?
It generally means they're only taxed on their U.S.-sourced income, not their worldwide income.
Ah, okay.
And they might also qualify for certain tax treaty benefits, depending on their home country. It's kind of a unique carve-out, designed not to immediately burden international students with the full complexity of the U.S. tax system.
Okay, that's interesting. So a non-immigrant for immigration, often a non-resident alien for tax, at least initially. Now let's compare that to the H-1B visa. I hear this one comes with a Well, a game-changing feature.
It truly is a game changer for many. H-1B visas are for skilled workers in what are called specialty occupations.
Meaning jobs that need specific degrees.
Exactly. Roles that typically require at least a bachelor's degree or its equivalent in a specific field. Think IT professionals, engineers, scientists, doctors, architects.
Okay, high-skilled jobs, and how long can they stay?
The H-1B is initially granted for 3 years, and it could be renewed for up to a total of 6 years, sometimes even longer in specific circumstances if a green card application is pending.
Right. But you mentioned a game changer.
Yes. Here's the real curveball, the big difference. Unlike most non-immigrant visas, including the F-1, the H-1B allows for something called dual intent.
Dual intent. Okay, break that down. What does that truly mean for someone like Alex if he switched from an F-1 to an H-1B?
For Alex, it means he can legally pursue permanent residency. That means applying for a green card while simultaneously maintaining his H-1B non-immigrant status.
Whoa! So he doesn't have to pretend he's leaving.
Exactly. This is a massive advantage because it essentially removes that strict non-immigrant intent burden we talked about.
Right, the need to prove you'll go home.
Yes. He doesn't have to maintain the fiction that he plans to leave the U.S. if he's actively legally seeking to stay permanently through a green card process sponsored by his employer.
That sounds like a huge weight off someone's shoulders.
It absolutely is. For many, it transforms what might have been just a temporary job opportunity into a viable, much less stressful pathway to building a long-term life here. It means you don't necessarily have to choose between pursuing your career in the U.S. and eventually settling down a constant tension for most other temporary visa holders.
That's incredible. So Alex could be here on his H-1B, his employer starts the green card process, and even if that takes years, he's not in limbo, constantly having to prove he'll leave someday.
Correct. He can keep renewing his H-1B within limits while the green card application is processing. It provides stability.
That makes a lot of sense, especially for attracting and retaining high-skilled workers. Okay, so that's immigration status. What about their tax status? Does dual intent affect that?
Not directly, no. For tax purposes, H-1B holders are typically considered resident aliens once they meet something called the substantial presence test.
Ah, there it is again. That overlap and potential confusion between immigration status and tax status.
Exactly.
Yeah.
You could be a non-immigrant H-1B holder for immigration law, but a resident alien for tax law.
Okay, the substantial presence test. I always hear about it, but it sounds like some kind of mysterious calculation. Can you demystify it for us? What actually is it?
Let's unpack it, yeah, because it's really vital for your tax obligations. It trips a lot of people up. The substantial presence test is not about your immigration status at all. Purely a tax test run by the IRS. Think of it like a point system, but for days spent physically in the U.S. To pass this test and become a resident alien for tax purposes, you generally must meet 2 conditions.
2 conditions. What are they?
First, you have to be physically present in the U.S. for at least 31 days in the current calendar year. It's usually easy.
Okay.
Second, you need a total of 183 days over a specific 3-year period. And this is where the calculation comes in.
The tricky part.
Right. The 183-day total isn't just adding up days. It's calculated by counting all the days you were present in the current year. Plus, 1/3, 13 of the days you were present in the first preceding year. Plus 1/6, 16 of the days you were present in the second preceding year.
Wow, okay, so it's weighted.
Exactly. It's a weighted average looking back 3 years. If you hit 183 days using that formula, and you met the 31-day test for the current year, then congratulations, or maybe condolences, depending on your tax situation. You're generally a resident alien for tax purposes for that year.
So it's not just a casual count. That specific weighted calculation, that explains why someone on a temporary visa, like an H-1B holder who's been here maybe a year or 2, could suddenly find themselves taxed like a U.S. citizen.
Precisely. They might cross that 183-day threshold partway through their 2nd or 3rd year.
Okay. Speaking of being taxed like a citizen, let's quickly revisit green card holders. We talked about their permanence and its limits. What about their rights and responsibilities from a tax perspective? Are they automatically resident aliens?
Yes. All green card holders, without exception, are considered resident aliens for U.S. tax purposes from the very moment their green card is issued. No substantial presence test needed for them.
So the green card itself makes them a resident alien for tax.
Correct, which means, just like U.S. citizens, they are taxed on their worldwide income. Everything they earn, anywhere on the planet, is subject to U.S. tax.
That's a crucial distinction. So their immigration status, lawful permanent resident, directly dictates their tax classification, resident alien. They're linked for green card holder.
Inextricably linked, yes.
Okay, now let's tackle the term that seems to cause the most head scratching: resident. It sounds so simple, right? Someone who resides somewhere. Yet you've mentioned it's notoriously ambiguous across U.S. law. Can you break down why it's so confusing?
You've absolutely hit on the biggest source of confusion. In common, everyday English, resident just means someone who lives in a particular place, right? Simple enough.
Yeah, like a resident of California.
Exactly. But in the specific context of U.S. immigration and tax law, the word resident takes on entirely different, very precise, and often conflicting meanings. This leads to major misunderstandings.
How so? Give me the conflict.
Okay, in immigration law, when officials use the term resident, they often specifically mean a lawful permanent resident, someone with a green card.
Got it. Immigration law, resident, green card holder.
Mostly, yes. But then you jump over to tax law, and the term resident, specifically resident alien, can actually include both U.S. citizens, though they're usually just called citizens, and foreign nationals who meet certain tests.
The tests being?
Holding a green card or passing that substantial presence test we just talked about.
Ah, so tax law, resident alien can be a green card holder or someone who just spent enough time here, like maybe an H-1B worker.
Precisely. So you can see how easily this single word, resident, can cause a lot of head scratching if you don't know which legal context, immigration or tax you're operating in.
Okay, let me try and rephrase that to make sure I get it. All green card holders are LPRs for immigration and resident aliens for tax. Full stop.
Correct.
But, and this is the tricky bit, not all resident aliens for tax purposes are green card holders for immigration purposes.
Exactly.
An H-1B worker, who is still a non-immigrant for immigration, can become a resident alien for tax just by being here long enough and meeting that substantial presence test formula.
You've got it. That's the key distinction.
It's like these legal Venn diagrams overlapping in really surprising and, frankly, counterintuitive ways.
That's a perfect way to visualize it.
So this raises a huge question then. Why? Why is this distinction between immigration status and tax classification so incredibly vital? Why should someone care?
Because it dictates your entire financial life in the U.S. I mean, fundamentally.
How so?
Your tax classification, whether you're a resident alien or a non-resident alien, determines everything about your U.S. taxes, what income you need to report.
Like worldwide versus U.S. source.
Exactly. What deductions and credits you can claim, whether you need to report foreign bank accounts, FBAR, and things like that, how you file your return, your filing status options. It's entirely separate from whether you hold a temporary visa, a green card, or even U.S. citizenship, although citizens and green card holders are always treated as resident aliens for tax.
So someone could be totally compliant with their visa, doing everything right immigration-wise, but be completely wrong about their taxes if they misunderstand their tax classification.
Absolutely, it happens all the time. Many people on temporary visas, like F1 students after 5 years, or H-1B workers pretty quickly, are shocked to learn they suddenly owe U.S. taxes on income earned back home, or that they missed out on certain deductions because they unknowingly passed the substantial presence test and became a resident alien for tax purposes without realizing it.
So for our friend Alex, if he came as an F1, he might have been a non-resident alien for 5 years, maybe filed simpler tax forms.
Right.
Then he transitions to an H-1B, maybe after a year or so, meets the substantial presence test, and boom, suddenly he's a resident alien for tax, and his worldwide income is potentially taxable by the U.S.
That's a very common scenario, yes. The rules changed dramatically for him, even though his immigration status only changed from F1 to H-1B, both non-immigrant.
Wow. Okay, so what does this all mean when we bring it all together? Let's try and summarize the hierarchy and the most important differences we've unpacked today.
Yeah, let's distill it down.
Okay, first, citizenship. That's the top tier, right? Most secure status confers full rights, complete membership in the U.S., virtually for life.
Absolutely. The gold standard.
Then we have green card holders or lawful permanent residents, LPRs. These are immigrants, they have permanent residence, the right to live and work here indefinitely, but still fewer rights than citizens, particularly voting. And crucially, their status can be jeopardized by things like extended absences or certain criminal actions. It's permanent, but not quite absolute.
Well said. That conditionality is key. And then below that, we have the broad category of non-immigrants, people here temporarily for specific purpose.
Right, a really diverse group. Students like our initial F1 Alex, skilled workers like H1B Alex, visitors, exchange participants.
Exactly. And the critical difference within that non-immigrant category, as we discussed, is that H-1B holders have that unique dual intent advantage.
Meaning they can actively pursue permanent residency, a green card, while legally maintaining their temporary H-1B visa.
Correct. This is generally not the case for most other non-immigrants, including F1 students. They're typically expected to maintain that non-immigrant intent, that plan to return home, although they can transition to other statuses, like H-1B, which might eventually lead to a green card. But it's a less direct path.
Okay. And crucially, that term resident alien, we need to hammer this home.
Please do.
It is purely a tax term, right? Not an immigration status.
100%.
Tax only.
It dictates your tax obligations based on either holding a green card or meeting that very specific physical presence calculation, the substantial presence test. And it's entirely separate from the type of visa you might hold or whether you're a citizen.
Couldn't have said it better myself. That's the core confusion we wanted to clear up.
Which explains why you see such vastly different work rights, pathways to green cards, and tax obligations for, say, F1 students versus H-1B workers, even though they might both be considered non-immigrants in the eyes of immigration law.
Precise. It's truly incredible how many different legal identities someone can hold simultaneously in the U.S. system, and how crucial it is to understand which hat you're wearing, legally speaking, at any given moment.
It really is. So as we've discussed today, navigating U.S. immigration statuses requires really a clear understanding of these terms: U.S. citizens, immigrants, LPRs, non-immigrants, and then the specific categories within them, like F1 students and H-1B workers. And we've also really tried to highlight that critical difference between your immigration status and your tax classification, particularly wrestling with that complex concept of a resident alien.
You know, understanding these classifications isn't just about memorizing definitions. It's really about appreciating the intricate legal frameworks that shape people's lives and opportunities here, and how even seemingly similar statuses can have profoundly different implications for an individual's rights, their responsibilities, and ultimately their future pathways in the United States. Well said. We really hope this deep dive has offered you some clear insights today and helped demystify these important and often confusing distinctions. All the best, and we will meet again with another important tax matter again.